The matter before the court is Hancock 23-371, Michael Good versus et al. Versus the Town of Bar Harbor. Counsel appear present. I'm assuming ready to proceed. We are being streamed live on the web as well as by video. And counsel, I would ask that we start by having you introduce yourselves for the record, together with the party that you represent, starting with the appellant.
Good morning, Your Honor. Jonathan Hunter for the Town of Bar Harbor.
Good morning, Your Honor. Max Coolidge for the plaintiffs.
Thank you. And Mr. Hunter, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. Good morning, Madam Chief Justice, Associate Justices. May it please the court. The question in this case is whether the Home Rule Act requires nullification of changes to the charter of the Town of Bar Harbor that were made by voters over 3 years ago, because those changes were presented in separate ballot questions rather than as a single up or down vote. The answer to that question is no. The Home Rule Act has different processes for charter modifications, for charter amendments and for charter revisions. Charter amendments may be placed directly on the ballot by the municipal officers for voters' consideration. Charter revisions, on the other hand, are more significant changes that require the creation of a charter commission, which engages in a potentially lengthy inquiry into the charter and ultimately issues a final report recommending changes to be presented to the voters. Ordinarily, amendments must be presented to voters as separate single subject questions, whereas revisions are presented as a single question. However, the statute permits revisions to be presented to voters in as many separate questions as the Commission finds practicable if the Charter Commission recommends that the present charter continue in force with only minor modifications. The Charter Commission did exactly that here. It voted twice to present the changes in separate modifications and presented them as such in their report, specifically calling them modifications. The changes proposed did not broadly rewrite or reorganize the charter, but rather made recommendations within the current structure of the charter. The Superior Court erred by somehow concluding that the Charter Commission did not make the requisite recommendation, and by failing to give proper deference to what is essentially a practical question for the Charter Commission as to how best to present the changes to voters. Even if there were any error in the manner of presenting the changes to the voters, the statute makes clear that only material and substantial procedural errors are caused to invalidate the will of the voters. Voters having more choice over what their organizing municipal documents say is not a material and substantial error. Indeed, it's the very reason the legislature allowed revisions to be presented in separate questions. Finally, the Superior Court compounded its error by refusing to permit the town to resubmit the proposed changes to voters as explicitly permitted by the statute. For all these reasons, and to avoid harmful and unnecessary interference with the municipal charter process, this court should vacate the decision of the Superior Court. I'd be happy to take the court's questions.
Counsel, if we were to agree with you that it was okay to submit these revisions or modifications in separate questions, what do we do with the rest of the plaintiff's arguments? I mean, they have several other arguments. This is, it comes to us, and those issues were not addressed by the Superior Court. Do we remand to the Superior Court? Are they legal questions that we address?
I think there are questions that this court can address in its de novo review. Obviously, the Superior Court did not choose to engage with those questions, but they're presented here as sort of alternative grounds for affirming the Superior Court's decision. So I do think the court could address those without a remand.
Well, I mean, if we were to agree, they have to be addressed one way or the other, right?
Right.
Okay.
I want to inquire a little bit the degree of deference that we are to afford to the Commission. The language of the statute provides that if the Charter Commission recommends that the present charter continue in force with only minor modifications, which is what they did, so what they said, is that the end of the road when, if the commission, charter commission says, hey, the charter's going to stay the same, these are minor changes, tee them up as individual? Or do we look behind that? The statute almost sounds like it's a per se or presumptive result as opposed to deference. So I'm a little uneasy about what the level of deference we have to give to the commission's conclusion that they're just minor and the charter stays the same, or whether we can look under the hood.
Right. It's a good question, Your Honor. I think, first of all, I think that the Charter Commission is probably in the best position to make this fundamentally practical decision about, essentially, the question is this a new document? Or is it fundamentally the same document with some changes to it?
Is that, I want you to answer his question, but is that really the fundamental issue here? In other words, that the argument over how minor it is really goes to whether it's fundamentally a new document or whether it's simply changing various little provisions that can stand or fall by themselves?
I think it is, Your Honor, and I think that looking at the relative significance of the changes is sort of misguided because, again, we are in the realm of a revision, which is the whole reason we had a charter commission in the first place.
So getting back to my question,
Sure.
I think you were leading up to it, but you said they're in the best position to make this judgment call.
Right.
And I think they probably are. But coming through the door, if they say it, is that the end of the road?
I don't think it's conclusive, Your Honor. I think there's at least a theoretical limit to what they could do. I don't know why a charter commission would do this, but if they decided to replace nearly everything in the charter and do it via separate, here's the first article of the new charter, we'll do that as a separate question. I don't think they could do that. I think that would be a place where the court might want to step in.
I sort of hear that as what the plaintiffs are saying here, that this is a rewriting of the charter, and that's exactly what the Charter Commission and the town is trying to do here, is rewriting this to such a large degree that it really can't fall under this umbrella we're talking about. I think that's the tipping point.
That is their argument. I would submit I don't think this is a close case. I think the significance of the changes and the number of changes have been vastly overstated. There's a reference to changes to almost every page of the charter. That's not accurate.
This may be a little extrajudicial, but is the current charter still in effect and these changes have been made?
The charter has been in effect for over 3 years.
With the changes?
With the changes.
So, counsel, just following up on Justice Mead's question, it's a matter of law, or a question of law, as to whether a proposal is a revision or an amendment.
Right.
Correct?
Yes.
But isn't it a factual question as to whether the particular circumstances that are put forward in the proposal meet those definitions? And if it is a fact question, who are we deferring to? Are we deferring to the Superior Court, or are we deferring to the municipal operative decision maker?
In terms of the decision as to whether the changes are a revision or an amendment, if that's what you're referring to.
No, that's a question of law.
Right.
Right. The question is whether these facts or these circumstances fall into either one of those categories. Didn't we say in fair elections that that's a fact-based determination?
It is, and that's a decision made by the municipal officers,
And so
not by the Charter Commission.
Okay.
The Charter Commission, I don't think there's nothing in the statute that contemplates that after the municipal officers have made that determination, is this a revision, is it an amendment, that we then go back and at the end, the Charter Commission then again makes a similar analysis. I just don't see that anywhere in the statute.
So the initial decision of whether it's an amendment or a revision has to do with the structure. We think it's going to be a wholesale revision, therefore we want a charter commission to take a look at this. And that is the idea of the minor modifications from the charter commission is we came back, we decided not to do we're not recommending a wholesale replacement or revision, but rather just these minor changes. And at that point, that's the process, as opposed to going back to the town to say, well, that's really amendments and not.
Right, and I think Maine Municipal Association in their amicus brief put this pretty well, which is that everything after the initial adoption of a charter is either a revision or an amendment. You know, if you completely rewrite the charter, that's a revision.
Whether a proposed change is a revision or an amendment matters really when a petition is submitted to the municipal officers.
Correct. And that was
Once
the
the
issue.
Charter Commission is formed, anything the Charter Commission comes up with is a revision. It can consist of a revision that must be put in a single question, or it can consist of minor modifications
Right.
that can be put in separate questions. Do you agree with that?
I do, and I don't see why the legislature would have created essentially a slower, more cumbersome way to
Now,
achieve an
one of
amendment.
the appellee's arguments is that some of the questions that were put to the voters separately were sufficiently interrelated that inconsistent votes could create a conflict in the charter. Doesn't that suggest that this set of modifications, unquote, should have been presented as a single question?
I don't think so, Your Honor, and I don't think that inconsistency actually exists here. But
Seems
more
to be
than that,
mostly with the warrant committee,
it's true.
membership versus review of the school budget,
Right.
et cetera.
The suggestion is that the change from 22 to 15 members of the warrant committee was solely based on no longer having the warrant committee review the school budget. But that wasn't the only rationale. There was another rationale, which was simply that the warrant committee is too big and it's relying too much on subcommittees, and they want the full warrant committee involved. But more generally than that, I just don't see this concern with consistency or inconsistency in the statute. Anytime you're changing the law, of course, there's a possibility of inconsistency, and the remedy for that is to change the law again, to fix the inconsistency. It's not to say to the voters, sorry, try again. And I certainly don't see anything in the statute that puts consistency on a higher level than respecting what the voters have chosen.
Well, the appellees seem to be arguing with regard, again, to the warrant committee, that the change, I think it's a reduction in the warrant committee's responsibilities, should have been included in the same question with the reduction in the size of the committee. That would have eliminated the inconsistency. They haven't made that argument directly, but that's what I'm gathering from their view of the contradiction between the two outcomes on those questions.
So I think the statute essentially says that once the committee has made the determination, or excuse me, the commission has made the determination that it's going to split it out into separate questions, it's up to the majority of the commission to decide how many questions and how those questions will be structured. And there was a minority report in this Charter Commission final report. It didn't take any issue with the way that the questions were structured. It took issue with some of the substance.
Thank you, counsel. Mr. Coolidge?
Good morning, Madam Chief Justice, Associate Justices. May it please the court. The Superior Court here made a sound decision based in well-established principles of statutory construction, and the plaintiffs here are asking for that decision to be affirmed in all respects. The analysis begins with the main Constitution, the Home Rule Amendment, that really has two sections to it. The first, the substance of what municipalities may enact, really broad discretion for municipalities to design their charters the way they want them to be designed. The second sentence in that amendment gives the legislature the power to decide the how, to prescribe the procedure for how municipalities will engage in the adoption and revision amendment of their charters. And the legislature has done that in the Home Rule Act that is at issue here in this case. And the Act is quite clear on this section when we're talking about a revision.
Counsel, I see that the green light is on. Can I ask you the same question I asked Mr. Hunter? If we were to agree with the town that it's okay to submit these modifications in separate questions, you have three other arguments essentially that you've raised with regard to why you think that it should be reversed, but the Superior Court didn't address those arguments. And this came to us on the grant of a summary judgment motion on one issue. Do we have to remand it to the Superior Court to determine, even in the first instance, whether there are indeed fact questions with regard to these other arguments?
In this court's de novo review, it could, if it also under that same standard, under the summary judgment standard, where finding no material fact, the court could rule on those issues. I think that remanding it would probably be the more prudent, proper procedure, especially if there were any factual determinations to be made at a hearing below on those issues. But the issue that the Superior Court did rule on it is sufficient to affirm this case. So this court can.
Well, let me focus on the statute that says no charter change can be found invalid because of any procedural error unless it materially and substantively affects the change.
Of course.
How can giving voters more as opposed to less choice ever be a material problem from a policy point of view?
Well, from a policy point of view, I think the important thing is that the legislature gets to make that policy.
Well, yes. So we have to define the legislative intent behind it. So what would be the policy that would make it bad to break down something into more questions to give voters more choices?
The policy reason potentially behind that, and I'm speculating here, the policy reason behind that is that requiring the Charter Commission to present a coherent whole could avoid inconsistencies and require the Charter Commission to present a revision that is going to be voted on up or down. It's going to either hang together as one whole or be voted down as a whole, rather than having multiple ballot questions. One could imagine a scenario where the town split it into 15 or 20 different ballot questions and could result in wildly inconsistent results. There was an inconsistent result here, but I think it's almost more important to think about the possibilities of what could happen in that case. So I don't necessarily agree that more ballot questions means more democracy or more ability to shape the charter. There are many ways during the process where the public can interact with the Charter Commission. They're required to submit a report. They're required to hold public hearings. So the requirement that the Charter Commission come up with a single question doesn't necessarily impact the voters' choices. And again, the policy.
I think it does. In your answer to Justice Connor's question, you used the term a coherent whole as it being a desirable thing. Isn't when the town seeks a coherent whole, they're talking about a new charter, a whole. It would be one question saying, here's a whole package of all sorts of questions here. It's a new charter, and there is a procedure for that. But however desirable that may be, if the enumerated questions don't create a coherent whole, but rather they're the opposite, very separate things, specific things within the existing charter, doesn't that fall squarely in the four corners of the statute, which provides for circumstances when the present charter continues in force with only minor modifications? I guess I'm taking a long time to say. You said a coherent whole is a desirable objective.
Yes, Your
but
Honor.
that would be for a whole new charter. And that's not what is happening here.
Well, what I would argue is that's the exact reason why the words only and minor are important adjectives that are in that phrase modifications. That in order to avoid potentially having inconsistencies, only truly minor modifications should be presented as separate questions in this way.
But isn't the key in that sentence really that the present charter continue, the recommendation is that the present charter continue in force? I mean, isn't that really key as opposed to recommending a wholesale replacement or revision of the charter?
Well, Your Honor, I guess it becomes a line drawing exercise if the charter can be rewritten 80%, 85%, is there a place where we can say that the present charter is really no longer in effect just because some of the words are being redacted and replaced with other
And
sections?
whose decision is that to make that call?
I would think that would be whose decision is to make the call, whether it's minor or not.
Whether the present charter is continuing in force with modification?
I think that's ultimately a legal question, and that's one of the reasons the statute provides for judicial review.
Well, let's go back to the statutory text in Section 2105. It says, it may be submitted to the voters in as many separate questions as the commission finds practicable. So it sounds like there needs to be a finding, sounds factual, sounds it's based on their decision as to how many questions are practicable. And so the issue, the policy issue is just if you have 8,000 questions, it's cumbersome. It may be more democratic, but it's cumbersome, and that's a decision for the Charter Commission to make.
Correct. That's a decision for the Charter Commission to make. But the words only minor, I think, are subject to judicial review. I think that is a legal determination.
Those words can't be reviewed in isolation. I mean, it has to be reviewed in the whole sentence and statute as well as what they did. I mean, isn't it a factual determination by the commission that we give the appropriate deference to?
Well, I think it's a mixed question because the factual determination, if the commission did say that, and I also just want to point out that the language that the commission used isn't clearly saying these are only minor modifications. They used broad sweeping language about a vision for the future of the town governance. So there's language in the recommendation that sounds more like a wholesale revision.
Well, they use the word modification.
They do use the word
each
modification.
time.
Yes,
Although
they
I
do.
note in modification number 1, they also reference recommended amendments. But be that as it may, is this a qualitative or a quantitative determination?
I think
if it's the latter, then isn't the word minor it's not relatively recent, but that's an amendment that took the place of an earlier statute which said few modifications.
Correct. I believe it's both a numeric, quantitative and qualitative decision in the same way that Fair Elections Portland talked about whether something is an amendment or a revision has to do with the breadth and depth of the change. So whether something could be considered truly a minor modification, I think does have to do with the whole, how much of this charter is being replaced here. I think that's a question.
How about a proposal that changed how councilors and the mayor are elected and dilutes the mayor's voting power on the council? Is that a revision or is that an amendment?
That could be part of a revision. I would say that probably could not be considered a minor modification.
I think it's a major modification.
It is. It's a change. It's a change.
The Supreme Court of New Hampshire in the Albert case disagrees with you on that, and we cited them quite favorably in Fair Elections Portland. They said that was not a wholesale revision.
So I think the question, the amendment versus revision question, is different than the minor modification versus major modification division that the Superior Court
The statute seems to equate minor modifications with amendments because it allows both to be submitted in single questions, separate questions.
I think that is a feature of both of them. I don't necessarily agree that they are the same. For example, amendments have to be single issue. That is the requirement.
Amendments are only voted, they don't involve a charter commission.
Correct.
Right? And this is a revision either way. In other words, a revision can either be so substantive and sweeping that it has to be submitted in a single question, or it can be the revision. I'm looking at section 2105 1A, which says that it refers to the determination to submit the charter revision in separate questions. So really the question is whether a revision is so substantial that it has to be put in a single question, so sweeping, or whether it can be submitted in separate questions. And isn't that the fundamental question here?
It is. That is the fundamental question here. But that
And what makes this set of minor modifications, as they're called, so sweeping that they should be viewed as the kind of fundamental change that requires a single question? You mentioned the warrant committee.
yes.
You mentioned, your brief mentions a change that allows the council to make minor amendments to zoning ordinances,
Yes.
but not to enact zoning ordinances. What else is there?
Well, that particular point, that the planning, the town council can make minor changes to the land use ordinance is quite a significant change for the town of Bar Harbor. Up until that point, that power had been exclusively with the town meeting. That is a change in the power of the officers of the municipality.
So changes to zoning ordinances that are required to comply with statutes, for example, should always be submitted to the voters? That's...
Well, no, I'm not arguing that they should always be. The town is certainly free to change its charter. That is what the Home Rule Amendment says. But that is the type of change. That is a type of change that I would argue cannot be considered a minor modification as contemplated in the statute.
Can I divert you to an entirely different question?
Of course, Your Honor.
In the Superior Court's ruling, the judge said essentially motion for summary judgment granted, plaintiff's motion for summary judgment granted, defendant's motion for summary judgment denied. But is that a judgment?
I'm sorry, is that a judgment?
Is that a judgment? Wasn't the complaint sought a declaration?
That's an interesting question, Your Honor. I
didn't see one.
I guess it is. I guess that granting the grant of summary judgment is a determination that the...
It's a granting of a motion. It's not an entry of judgment, is it?
I don't know. That's an interesting question. I don't have an answer for you on that.
Our review is deferential. To what degree do we defer to the commission when the commission says, present charter stays in effect, these are minor modifications? Is that presumptive? Is it per se? Is it a rebuttable presumption? To what degree of deference do we give to the commission, who, as Attorney Hunter indicated, is entitled to deference?
Well, I guess I would argue the question about whether something is a minor modification is not entitled to deference. That's a legal question. The determination of the facts that the commission looked at to make that determination are entitled to deference. But the judicial review of whether something truly is a minor modification or not is something that needs to be reviewed de novo. That was something the Superior Court...
Why isn't it more like a mixed question of law and fact in which we give town bodies some deference?
Well, again, I think giving deference to the factual determinations makes sense. It is a mixed question. But the question about those modifications have to be truly minor in order for them to survive judicial review. And I think this case, the scope and amount of those modifications, the Superior Court correctly exercised de novo review of that, and I would argue this court do as well. Thank you.
Thank you.
Just had a few points that I wanted to address. With respect to the remand question, plaintiffs have said in their brief on page 2 that there are no genuine issues of material fact and that the documents speak for themselves. So I don't think a remand is necessary.
Is there a final judgment?
You know, that's an interesting question that we had not considered. I did point out in my brief that arguably this should have been brought as an ADB appeal instead of a declaratory judgment action. I don't know what the court does with that, Your Honor. I think in terms of your review, it's essentially 6 of one, half a dozen of another, but that might play into whether or not there needed to be a specific declaration at the end of the day. In terms of some of the flowery language used by the Charter Commission, the vision for the future and that sort of thing, I think it's very dangerous to read into that too much, because if you look at the other language, they reference that they're making changes to the current charter several times, and even say that they're recommending that the council look at a grammatical review of the whole document because of all of the changes that have occurred over the years. So it's clear that they view this as a continuation of the old charter. And finally, this court said in Fair Elections Portland that a plain language interpretation should not be confused with a literal interpretation. It also acknowledged in that case that this statute is pretty spare when it comes to saying what the legislature meant, and you have to look at the whole structure to really see the full picture. And I think if the court does that, it'll see that the Superior Court got it wrong here.
Thank you, counsel. Thank you to both of you. As is our usual practice, we will take the matter under advisement, issuing a written decision in due course. And with that, we'll be in recess on this matter.